Further hearing in the Cornerstone and non-tower appeals.
Yes. Thank you, Lord. May I start with a reference? My Lord Burrows yesterday asked me for the reference to the Court of Appeal judgment as to what parties may or may not be able to do by way of consensual variation. And it's in the Ashlock judgment, paragraph 68, Lord Justice Lewison's judgment, and that's at 744.
Thank you.
Now, at the break yesterday, I was going to paragraph 30 of the code, and if I may, I'd like to pick up there. That's page 1833 of the bundles. And we've observed that the phrase is site provider, which is defined to mean the person who has conferred the code right or the person on whom it's otherwise binding in 31A. And we've seen that paragraph 30 then works to continue the protection for a particular purpose in 2, which is that the operator may continue to exercise that right. And so I suggested that that was equivalent to the continuation of a tenancy under 1954 Act and enables a tenant to continue his rights so long as he stays in occupation in that Act, in this Act, basically so long as he wants to exercise the right.
How does he leave occupation? I mean, are they required by the regulator to dismantle and take away equipment that is no longer necessary? It seems unlikely that they're just allowed to leave these masts scattering the countryside.
If you keep your material on site, you're still occupying it with that material. And so in order to make sure you want to clear the site altogether to enable you to take advantage of this provision, you would have to take it with you. And usually it's the subject of the code agreement that at the end of the term they will pack up and take their material with them.
Does this point have any bearing on the issues on the appeal, or is it just one of interest to the aficionados in this area?
It's possibly the latter, but it's important to understand the workings of 31 and 33, and the point is that both types of code right, that's the original conferral of code rights and the binding agreement, both of them continue for so long as is required to operate the Part 5 procedure to its conclusion. And then we go to paragraph 31, and there's a right for a site provider who is, as it were, the landlord, on the landlord side of things, to bring the agreement to an end on the particular grounds stated in 4, which track some of the grounds in the 1954 Act. But the important point to observe for my purposes is that the site provider who can do this is explained in 31(1) as the site provider who is a party to a code agreement. And it's that person who may bring the agreement to an end by giving a notice and so on. And it's that concept of the site provider being a party to the code agreement which underpins the operation of Part 5. It doesn't mention anything about who's in occupation or rights of occupation or anything of that kind. And of course that's the site provider, and he's not going to be in occupation anyway. But the point is more important when one comes to consider 33, which is under the heading, how may a party to a code agreement require a change to the terms of an agreement which has expired? And the right is given to an operator or a site provider who is a party to a code agreement by notice in accordance with this paragraph to require the other party to the agreement to agree that, and then the various things. So this is a notice between the parties to the code agreement. And that explains the significance of the provisions we saw in paragraph 10, which says that where you have a successor to a party, a successor in title that is, then the successor in title is to be treated as a party to the agreement. And so the successor in title is the person that one is looking at for the purposes of paragraph 33. And then it's important to look at what 33 enables to be done, which is 33.1. It's requiring the other party to the agreement to agree that, and then one of four things. The code agreement should have effect with modified terms. B, where it confers more than one code right, that the agreement should no longer provide for an existing code right to be conferred by or otherwise bind the site provider. C, the code agreement should confer an additional right, code right, on the operator, or provide that the site provider is otherwise bound by an additional code right, or the existing code agreement should be terminated and a new agreement should have effect between the parties, which confers a code right on the operator. Now, the ultimate purpose of the notice, therefore, is one or more of these things, modified terms. That suggests that you can't have any other application under paragraph 20 during the currency of the agreement for modified terms, because this is the way in which that aspect of the matter is intended to be dealt with. You get a code agreement in place, and then, short of consensual variation, the only way you can get a change is by waiting to the end and operating the Part 5 procedure. The same is true, I would suggest, of C, which is the conferral of an additional right. So that's one thing to register. The next thing to register is that...
What policy reason would there be for not mirroring the right during a fixed term for the parties to agree a variation by a power for the tribunal to impose a variation? What's the policy reason behind freezing everything in time until Part 5 kicks in?
To avoid the landlord being beset by multiple applications. It's costly for the landlord. The landlord's not making huge money out of this. And these issues have to be dealt with. And it's burdensome for the landlord to be subjected to multiple applications. So what's envisaged is that everything will be dealt with up front. It will then be a firm agreement binding on the conferrer and his successor in title. And then it can be reviewed and looked at again after the termination of the current agreement. The point I was going to make was that one of the end points of this is that the code agreement should confer an additional code right, and indeed that a new agreement should have effect between the parties which confers a code right. That suggests that paragraph 9 is still in play, or one might think that paragraph 9 is still in play because rights can only be conferred by an occupier. But we'll see there's a specific provision which shows that you don't actually need to consider paragraph 9 and who is the actual occupier of the land. So far as 33 is concerned, all that is required is that there is a notice by a site provider who is a party to a code agreement, and once that notice is given and the relevant time has elapsed, an application can be made in relation to it, and the court can make the order. So let's just look ahead at that. 33(2) specifies, in B, specifies various matters of timing, that is the day from which you're going to operate your revised position, and it has to, this is C, has to set out details of the various rights that you're seeking, as the case may be, and then subparagraph 4 is, subparagraph 5 applies if after the end of the period of 6 months, beginning with the day on which the notice is given, the operator and the site provider have not reached agreement on the proposals in the notice. And where this paragraph applies, the operator or the site provider may apply to the court for the court to make an order under paragraph 34. So we go to 34, and one is that the paragraph sets out the orders the court may make on such an application, and those are listed at 2 to 6. 2 is basically there's no change, save that for such period as may be specified in the order, so that the code agreement has effect accordingly. So one option is that things continue as they are for a defined period. And then 3 to 6 track the matters we've seen, which are modification of the terms, losing one of the code rights, ordering the conferral of another of the code rights, and entering into a new agreement which confers a right, and so on, and terminating the old one. And then there are provisions in 34 as to the new agreement taking effect, that's 7 and 8, and then the terms that are to be provided, and then 10, if the operator and the site provider are unable to agree the terms, the court must on an application by either party, make an order specifying those terms, and then there are a number of provisions as to what the court is to take into account on an application for that purpose.
What happens if the parties do reach agreement on the terms and don't need to involve the court?
Then there's no application, because...
But then how does the new agreement take effect? Under paragraph 9?
No, that is the point I wanted to take your lordship and your ladyship through in some detail, because it's 34(8) is the solution. And Lord Justice Lewison explained how that is a solution, and I'm adopting his reasoning as part of my own, but for the purpose of my submissions, perhaps I can deal with it straight away, in fact, since your lordships asked me. The reasoning of Lord Justice Lewison is in the Compton Beauchamp appeal, which is page 222 of the bundle. And this is at 62 and 63. 62, his lordship notes the provision of 34(8), which is this code applies to the new agreement as if it were an agreement under Part 2 of this code. This is clearly a deeming provision. If, as stated in that paragraph, the code applies to the new agreement as if it were an agreement under Part 2, it must follow that the code applies as if it were made between the operator and the occupier in accordance with paragraph 9, that being the only way in which such an agreement may be made. Although paragraph 34(8) is part of the paragraph dealing with orders that the UT may make, it's not on its face restricted to a new agreement ordered by the UT. It would fit the scheme of the code if paragraph 34.8 also applied to a new agreement made by an operator, made between an operator and a site provider, and in my judgment, it should be so interpreted. So the solution, Your Lordship asked me, is, as found by Lord Justice Lewison, is that 34.8 is a deeming provision which overcomes what would otherwise be required, which is an agreement between occupier and operator. The particular point he's noted is that 34.8 appears in the context of the court's powers, or the court's powers to grant rights, but nevertheless, you can read the new agreement to apply both to the consensual agreement and to whatever agreement is imposed by the court pursuant to this process. And there's just a couple of points I'd ask the court to note that support that reasoning. Maybe they were part of Lord Justice Lewison's consideration, but he doesn't expressly say so. But there are two things to note. One is that although his lordship is right that in general terms this clause appears in the context of the orders, what orders the court may make in the court proceedings, paragraph 34, paragraph 34.1 has a slight inaccuracy which perhaps points to certain paragraphs having a wider effect. Paragraph 34.1 says, this paragraph sets out the orders that the court may make on an application under paragraph 32.1 or 33.5. But the thing is, it does do that, clearly, but it does rather more than that, because as we've seen, the orders that the court may make are dealt with between 2 and 6. We then move on to 7 and 8, which is some provision about what the new agreement does. 9, we move back to what the court can do, the terms conferring or providing for an additional code right and so on. They are to be such as agreed between the operator, and if not, the court must make an application, or on an application, make an order specifying those terms. So 9 and 10 are also about the court's rights, obligations.
So what you're saying is that what's missing is something in 33 between 3 and 4, which should say if they do reach an agreement, then the code applies to the new agreement as if it were an agreement under Part 2. And if they don't, then you go on. But that's not been put in. So you have to treat 34.8 as if it said that.
Correct. So my first point is that you can do that perfectly easily, because 34.1 explains what it's about, but it doesn't cover everything that 34 is about. Because a lot of it is about what considerations the court should take into consideration on applications of this kind. That's 11 to 15. 1 to 6 and 9 to 10 are about what orders the court can make. 7 and 8, it's not entirely clear whether it's intended to apply just to those orders or more widely. My suggestion is there's nothing wrong in the interpretation that Lord Justice Lewison put on it, because Clause 34 is not only dealing with what it said it was dealing with. And the other point I'd want to take the court to is that the phrase "the new agreement" is also the phrase used in the notice procedure, and is the phrase, including the phrase that's used in relation to a brand new agreement. So looking back to 33.2, the notice must specify for the day on which it is proposed, the existing code agreement should be terminated, and from which a new agreement should have effect. So it's a new agreement. And then C, it should set out details of certain things, and then the proposed terms of the new agreement. And then with those words, that phrase ringing in one's ears, as it were, when one comes to look at paragraph 34, 7 and 8 look as though they're intended to apply to both voluntary and imposed agreements. The existing code agreement continues until the new agreement takes effect, and this code applies to the new agreement as if it were an agreement under Part 2 of this code. And so there's nothing odd in interpreting those two subparagraphs to mean that if you have a consensual, agreed new agreement, then it will supplant the continuation of the existing agreement. When it takes effect, it then controls things. And as regards the deeming provision applies to that new agreement, even though it is conferring rights.
I suppose the other possibility is the drafter didn't think he needed to put in anything for the voluntary agreement because it's already covered by paragraph 9.
Yes, because it's a modification.
Because it's just an agreement conferring code rights.
Yes, my suggestion would be it's more likely to have been because it's a variation of an agreement conferring code rights. The first few.
Oh, I see. It could be either a variation or
Yes.
a brand new.
In other words,
agreement.
You've got three types of modification in effect.
Yeah. And
one termination and new agreement.
Yeah.
So the only new rights that need to be conferred outside that process is the new agreement. Mm. Everything else can work as a modification, as a permitted modification.
Mm.
So the deeming means that the new agreement sort of jumps over the paragraph 9 problem. But is that then for all purposes, that for all purposes the new agreement is not an agreement under which the operator is the occupier, so that when you have the new agreement it doesn't have the problems that we were discussing about paragraph 26 and 27, or is it only, does it only get over the paragraph 9 problem in that moment in order for it to be entered into, but then it still does have all the same problems of being an agreement with an operator who is also an occupier for the rest of the application of the code?
Well, the answer to that would be that there's no need to consider who is the occupier for the purpose of a renewal procedure. All that you need is an agreement between the site provider and the operator in accordance with the notice procedure that's set out. Once you've got such an agreement, it takes effect as if it were an agreement under Part 2, that is to say, a voluntary agreement.
So you don't ever need to go back into Part 2 or Part 4?
Exactly. And you see, therefore, that Part 2 has effect essentially as the originating agreement. But once you are into the originating agreement, then everything rolls forward without the need to consider occupation again.
But, I mean, subparagraph 8 says it takes effect as if it were an agreement under Part 2.
Yes.
So surely that means that the provisions which are applicable to such agreements, which include Part 4, will be applicable to the new agreement as it goes forward, won't it? So when my lady says, does the new agreement carry with it the problems with paragraph 26 and paragraph 27, it will carry those problems. You may have answers to that, But you would still be looking potentially to operate a paragraph 26 or paragraph 27 procedure in relation to what is a new agreement deriving from Part 5.
Yeah. It's difficult to see that paragraph 26 would be relevant because that has been glossed as either a freestanding application or an application for interim rights pending a paragraph 20 application. So in what we're looking at here is we've already had, as it were, the paragraph 20 procedure. We know what the agreement is. There's no scope for interim rights. So that's all spent. So far as temporary rights are concerned, then yes, that would apply because at the end of this agreement, or indeed the renewed agreement, there may be circumstances where the agreement is brought to an end and somebody wants to recover the land and remove the apparatus. Now, those are the circumstances in which paragraph 27 comes into operation, and they would, of course, apply.
Might you not, in principle, want to use Part 20 in relation to the new agreement if you want, for some reason, somebody else has come along who you need to have bound in, who's now asserting some right?
Yes, I'm talking. It's important to make the distinction between paragraph 20 applications which confer rights, and that's the point I'm addressing at the moment, which is the paragraph 9 point.
Yes.
So, conferring rights, of course, we say that is dealt with under the originating process, either consensually or under paragraph 20. That's dealt with, and then it gets renewed without reference to anybody's occupational status. I entirely accept my Lord's point that, of course, if there are third parties who need to be bound for some reason to this agreement, some point has cropped up, that could crop up at any time. And that kind of application under paragraph 20 is capable of being made to square off difficult problems that might have emerged with a third party. But that doesn't conflict with the overall position that, so far as the landlord is concerned, that is the original person conferring the rights, he's not going to be beset by further applications.
But you say that Part 20, paragraph 20, would be relevant in relation to third parties. Potentially, it could be relevant between the parties themselves if their agreement doesn't already cover all the code rights and the operator wants a new code right against the existing party to the code agreement.
Well, my submission is that that doesn't work for the reason that you have Part 5, which enables modification of terms, including the grant of additional rights, to be dealt with at the end of the current agreement.
I see, and you say that covers the new agreement, so you're in effect limited to how far you can vary the agreement in the same way as you say you are in relation to the original.
Yes. The logic being that if your Lordship's suggestion were approved, which is that you can go back under paragraph 20, then you never need Part 5 at all. You can always go back under paragraph 20 whenever you want and ask for some new agreements or some new terms or whatever. That's not how it works. You've got a specific right to apply for modification, additional rights, and termination and renewal. But that takes place at the end of the current agreement.
But you could achieve that. I understand that point, that it doesn't make sense, you say, to be able to bypass Part 5 by making paragraph 20 applications. But you could achieve that result through an interpretation of the code, which, even if Mr. McGee is right to say that the operator is not the occupier by reason of installing the ECA, it would just be an interpretation that says, look, there's part 5 there, that's obviously what you're meant to use. You're not supposed to use paragraph 20. In order to achieve that, do you have to have this occupier-operator problem?
Well, or at least my answer to that would be, all we've got is the code. This is the way they actually did it. There may have been other ways of doing it, but what they actually did was this. They set out you can have rights conferred at the outset, as it were, by an occupier to an operator. If he doesn't agree, you can go and get those rights. That agreement then governs until it terminates, at which point you have the right to seek a whole menu of possibilities to govern the future period after termination. And in the period between the end of the agreement and the beginning of the new agreement, it all continues as it was before.
What stops you going back to get a new code right during the currency of the agreement? Is it simply the occupier-operator problem, or is it something else as well?
No, it's
The Part 5 regime.
It's the Part 5 regime.
By implication, excluding such application during the currency of the agreement.
Right. And so it's nothing to do with occupation. It's not because the operator might have gone into occupation. No. It's because the regime is such that you only get the chance to seek a new code right after the conclusion of your existing agreement.
You mentioned paragraph 34(2), which indicates that the court can effectively reset a fixed term. Another 10 years, say. Is there a provision that then supports that by saying, and if the court does that, then there can't be any different Part 5 applications during the course of that fixed term? That's then frozen.
Well, the point is, just looking at the way the sections are organised, the first one is 31, which is the site provider applying to get rid of the operator for, say, redevelopment reasons. So that's the first one situation being dealt with. One possible outcome of that may be that the site provider loses, in which case, what do you do with the agreement? Section 30 says it's continuing, and paragraph 34(2) would suggest that in circumstances like that, it will just continue to whatever time the court decides it should continue. Separately, or maybe alongside, there may be notices that, on the assumption that the site provider loses that case, I, the operator, want a new agreement with the following modified terms. And then there's a separate case that needs to be dealt with, dealing with the renewal or the modification. So when you get to 34(2), one of the options for the court to say is, no, I'm just going to leave it as it is. The court probably wouldn't do that, or would only do it on a temporary basis, if there were some live proceedings brought by the operator rather than the site provider to change the terms. I suppose it could be by the site provider as a fallback case as well. He might say, well, if I'm stuck with them, can I at least have the following change? So anyway, it's all in the court's hands as to what to do at the conclusion of whatever issues are before the court at that stage.
Yes, but what I'm asking is, if the court says, right, this is going to be for, I'm imposing another fixed term of 10 years, does that then preclude any applications by either party under Part 5 during that 10-year period?
Any applications under paragraph 20?
No, under Part 5.
Yes, I expect it probably would. It would be a final conclusion. But
is there anything that says that? if the site provider goes to the court and says, I'm finding all these applications by the operator very burdensome and time consuming, I just want to know where I am for the next 10 years, please amend this agreement so that it's another fixed term of 10 years.
Yeah.
Does that effectively oust?
Well, theoretically, yes, but in practice, possibly both parties, but at least one of the parties is likely to say, I don't want 10 years. I want to exercise some of my rights to modification or to get a new agreement or whatever it is. So please don't make it at such a long period that I can't now proceed to exercise my rights as they are at the moment. So
I don't understand where you get the implication from in the code that you can't make a Part 20 application during the currency of an agreement. The reason you have Part 5, as I thought, was that because once the agreement has expired, then you need a new procedure, and Part 20 won't do the job. And also, there's a right in paragraph 31 for the site provider to make an application, which I don't think he has under paragraph 20. So how do you deduce, without any express provision, as far as I can see in the code, from the existence of Part 5, that you can't make an application under paragraph 20 during the currency of the agreement?
It's because it's not just renewal of the agreement that's at stake here. The paragraph 33 sets out that the requirement to the other party to the agreement includes the agreement should have effect with modified terms.
But that's all after it's expired.
After it's expired.
So why can't you, well, there's no conflict between that regime and allowing you before the agreement has expired to make applications under paragraph 20?
Why not? In the sense of why would Part 5 need to exist at all?
Because after the agreement's expired, then
You need a new agreement.
then you need a new. Then you don't have the existing agreement to vary consensually, or if in the absence of consent, to go to court under paragraph 20.
But my answer to that would be on your Lordship's proposal. You can do all that under paragraph 20 if paragraph 20 is available. You can say, I'll have some new rights, please, or some modified rights.
When?
During the currency of the agreement.
Yes, I don't see why not.
Well, my suggestion is that it's supposed to be fixed for the period.
Well, I didn't say that, but there's nothing in the code that says so.
Well, yes, I mean, I am certainly saying it's a clear inference to be drawn.
And Part 5 is dealing with the situation after the agreement has expired, and therefore it's not. That's when if you can't make a new agreement, you need some procedure, don't you, for continuing the old one? Or modifying it, or replacing it, or whatever you want to do.
Well, I make my submission.
Yeah.
We suggest that that position is a clear corollary of having the Part 5 rights. What we do point to as part of that consideration is also this. Paragraph 34(8) overcomes any difficulties that would exist on the occupational front. That's the paragraph 9 front. And that is not something that is provided for any putative application that your Lordship is positing under paragraph 20 during the currency of the agreement. So in other words, there's no equivalent deeming provision.
Sorry, there's no equivalent deeming provision if you go under paragraph 20. I thought paragraph 22.
Yeah, I thought so too. Paragraph 22.
Yes, the wording is slightly different. Paragraph 22 says that the agreement imposed takes effect for all purposes as an agreement, whereas 34(6)(8) talks about the new agreement being as if it were an agreement under Part 2 of this code. The latter is a more clear indication that the new agreement might not be an agreement under Part 2 because you've not got an occupier granting the relevant rights. Now that's different from a position where you have to prove that the occupier can grant the rights under paragraph 20 in order to get the relevant order.
Well, it might be said they both look pretty clear. But just on the question of implication, what one can get from the fact that Part 5 is there, I wondered whether you might be able to say a little bit more in response to Lord Legate's question. Because, I mean, Part 5, the heading might be read as general. This is page 1833, termination and modification of agreements. So I suppose that's you could read that generally and say that's covering all forms of modification.
Yes, I did yesterday. I hope maybe the position as the point's been lost overnight, but yesterday I did draw attention in paragraph 28.
Yes.
To the point that C is the procedure for changing an agreement relating to code rights. Mm. And I think I made the point in that context that that's why we say Part 5 is to be read as being the only means by which you can change code rights once an agreement is in place. And that's perfectly general language, changing an agreement. And it could be a modification or having a new agreement as the provisions then go on.
Although, in relation to that, I think you accept, don't you, that, for instance, you can have a variation of an agreement relating to code rights.
Consensually, yes.
Consensually. So that would suggest that one ought not to read paragraph 28C as exhaustive of the procedures for changing an agreement relating to code rights.
Yes. The point is that you can agree whatever you like, but it may not create a code right if you're not in a position actually to confer it. And then the position would be that when you get to the end of your existing agreement, you would have it modified, or you would have a new agreement to put it into a form in which you do want it to be, and then everything would be regularized as a new agreement as if it were made under Part 2. So during the current agreement, consensual variations are operative as between the parties to it. Whether they bind third parties depends upon whether they're code rights. Oh, I see.
Can I just go back to a point which, trying to look at this in the overall strategy as to what the legislation is trying to do. I think you said that Part 4, we don't want to allow this to be used during the currency of a code agreement because one doesn't want multiple applications made against the landlord. Why wouldn't that be something in the court's mind when applying the test under paragraph 20, under Part 4, that might well be something that ought to be avoided? I mean, why isn't that something that would play in any event?
On the discretion, you mean? The exercise of
it depends how you're actually describing what's going on under Part 20, but if you want to say the application of the test or the discretion, however you want to phrase it, yeah.
The problem for the landlord is not just the outcome, it's also the process. So it's too late to leave it to the court to make determination, because the time you get to the court's determination, all the costs have been incurred, and you might still lose. The point about certainty and not having any change while the existing agreement is current is that the landlord is not exposed to cases of that kind, further applications under paragraph 20. And therefore the costs associated with court applications. Now he can agree something, that's fine. Or he can say, I'm not going to agree anything. I'm happy with the agreement that I've got. And when that is the case, the operator will just have to wait until the end of the current agreement before bringing to the court's attention the particular issue he wants to have resolved. But the only practical consequence of all of this is that the operator would be well advised to get everything he could possibly want in the way of code rights and terms at the very beginning. And indeed, as I took your Lordship and your Ladyship to yesterday, on the illustrations we've got in the documents before us, that's exactly what they do. The notice is the all singing, all dancing, all code right agreement that is required in each of these three cases before the court.
Is there anything clear set out anywhere that that is the policy?
Offhand, I can't.
I mean, it's not something that permeates through the Law Commission recommendations, for example.
I can't think of a reference offhand. We'll think about that, my Lord.
I realise you're saying, well, this is the way one must interpret the code because that's how it's set out, but underpinning it all, we've got this question as to the balance between the landowners and the operators, and you're putting forward a very fixed policy that favours, in some respects, the landlords, so they know exactly where they stand. The counter-argument might be that the purpose of this code was to some extent to make things relatively straightforward for adaptation to new circumstances by operators. And on that basis, it would look a bit odd that one would sort of have this sort of freezing idea from the start.
Well, if the logic of the way in which I present it, present how the code works, is that the operator will get everything it needs up front, then there's really no reason or occasion to consider that there would be changes required during the currency of the term.
In support of your point, there is the fact, I think, that although Part 5 contemplates the site provider applying to remove rights that have been granted in the rolling on period, there's no equivalent of paragraph 20 for the site provider. Is that right? So
That's true, yes. That is true, yeah. Yes, and that is a point I would pray in aid, my lady, yes.
Although para 33 is headed, how may a party to a code agreement require a change to the terms of an agreement which has expired, is it confined to an agreement which has expired?
Yes, it is, because you can only have the notices, the notice procedure operated if the agreement has expired.
Right.
it might be thought consistent with the way the transitional provisions were put in place, that the underlying policy was that parties were held to their bargains. Existing agreements would run their length. And your approach would suggest that approach in relation to transitional provisions was also being applied to the code itself.
That would certainly make sense. Yes. Of the way in which we say the structure works.
Yes.
Sorry, I've been given a reference, if I could just check it. Oh yes, that's right. In answer to my Lord, I think it was Lord Burroughs' point, there is in fact, of course, the reference at 3275, which is the government response to a consultation under issue 5, the heading modifying agreements. The context is set out. 366, this means where one party wishes to amend the code and the other does not, or where the parties agree a code agreement should be amended but cannot agree the terms of that amendment, they are unable to seek a resolution through the courts. Instead, they must wait until that current agreement expires and then apply to the court for the imposition of new terms. While we agree this is the correct position in most cases, and that code agreement should provide all parties with as much certainty as possible,
Go on to 3.5.
Yeah, and 371 is perhaps the crucial conclusion, which is that the government is deciding that they don't have sufficient evidence to support making reforms which would allow the courts to modify an ongoing code agreement.
We see from 3265, this was a consultation outcome document updated as recently as 24th of November last year.
Exactly.
So how can we rely on anything it says as a means of interpreting the code set up in 2017?
Yes, and I don't put it forward on the basis that you can.
No, it would be an interesting approach to statutory interpretation if one were to do so.
And I'm not saying that, but I'm just answering the question of, is there any indication of the government's consideration of this issue? Answer, yes, there is. This is it.
I mean, even this is a little bit ambiguous, isn't it? Because 3.65, it seems to be being assumed that code agreements can be amended during their life voluntarily, i.e. across the board, including conferring new code rights.
Yeah.
Yes.
It's for the court to modify. It's talking about whether the court should have power to modify.
Well, 3.65 is positively saying the parties can voluntarily modify,
Yeah.
Yes.
which on your argument, they couldn't do across the board. Anyway, probably not very helpful, ultimately. Could I just ask about the practice under Part 20? I take your point about cost. Presumably, if you actually get to the point of applying to the tribunal, it has a power to grant costs to whoever wins. But as I understood, you were making a point about, well, there are going to be costs where the landowner has to consider an application which may not eventuate in a court application, and so they won't get their costs back that way. In practice, do parties negotiate around the costs at that stage? So, for instance, if you're an operator, you're going to a landowner, I can see it's a burden on the landowner. Do the offers made include, and we'll pay your costs of considering this application?
Well, of course, any offers can do that kind of thing. I don't have the experience to be able to say whether that is general or usual. And I'm not sure how one would go about testing whether it's general or usual.
Right.
It all depends on the individual application.
I was just wondering whether under paragraph 21, looking at the first condition, sorry, this is page 1822, 21.2, the tribunal will only make an order if the prejudice caused to the relevant person by the order is capable of being adequately compensated by money, whether that would include, if you like, covering the initial costs of the application, so that the operator, knowing that they may be bargaining against the possibility that they would make an application to get an imposed agreement, and of course the landowner would know that, would in effect know that they had to offer the landowner to pay the costs of the application, even if you don't go to court, because if you did go to court, the court would say, well, you haven't sufficiently compensated the prejudice to the landowner because you didn't make an offer that included the agreeing to pay their initial costs.
Yes, they're two slightly different things, aren't they? The cost of the application isn't necessarily the prejudice to the...
No, that's why I was trying in my question. I probably didn't.
We have, I think, in paragraph 25, a definition of what the compensation extends to.
Yes.
And this is at 1824, and it's compensation for loss and damage as a result of the exercise of the code right.
Yeah.
Which,
rather than the grant.
Rather than the process of application and grant.
Yes.
So it seems to me that ties in with the balancing exercise in 21, or the exercise in the first condition in 21.2, that the prejudiced cause is capable of being compensated by money. What they're talking about is the prejudice caused by the exercise of the right. Because when I first read 21.2, I thought, well, where is the compensation provision? And I think 25 gives the answer.
Well, 25 is certainly the compensation provision, but as your lordships indicated, that does not cover the costs of getting there. And it perhaps is less of a point for my client because we're a professional landowner,
yes.
Landlord of this kind of situation. But you think of somebody like Compton Beauchamp. They've thrown a huge amount of money to defend what they see as their rights under the code. They've won in the Court of Appeal, but essentially they're exhausted now. And the costs of conducting an appeal to this court are then prohibitive. So they've had to drop out. Now, this is perhaps a rather extreme example, but for the general landlord, it could be anybody with a very limited right to make money out of his property. This could be taking place on residential property, for example, if the site is suitable. And you can't therefore assume that the relevant landowner is sufficiently resourced to be able to take all the points that are available to him, with the result that his position can be overborne. So the fairness of these provisions is that you can't modify during the term. You are stuck with whatever you agreed at the beginning. The landlord is not beset by further applications and doesn't need to worry about it. And the costs are kept to a minimum. Now, if your lordships and your ladyship would give me a moment, I departed from my course in order to answer my Lord Legate's point, which is the essential point of which is 34.8, yes, and the deeming provision and the application of the deeming provision, and that is therefore the solution that's found by the Court of Appeal, and we in this court, we support that conclusion. And the consequence of it is that there's no question of occupation being a relevant issue for the purposes of renewal or modification. So the issue that my friends are relying upon, upon which they say this court should intervene to redraft part of, essentially to redraft the terms of paragraph 9, is limited to the position that arises on initial conferral of the relevant code right. Everything else is deemed satisfactory, and the renewal takes place without relevance to that issue. And that's an important conclusion to draw when one's considering whether or not to make any changes. So I was going to go on to consider the position during the currency of the agreement, but I think we've probably already explored that in the course of my submissions. The end point of it is simply that there's no practical problem once the original code rights have been granted and the agreement is in place. So that's what I was going to say about Part 5. Part 6 is the next matter to consider. I'm going to come back to 26 and 27, which are at the forefront of my friend's case against me. But we need to look at the Part 6 just to understand the structure of the code. Part 6 is on page 1838 and is under the general heading of rights to require removal of electronic communications apparatus. And 36 is the introductory, which tells you what this part is all about, and it makes provision about the cases in which a person has the right to require the removal of electronic communications apparatus or the restorations of land, the means by which a person can discover whether apparatus is on land pursuant to a code right, and the means by which a right to require removal of apparatus or restoration of land can be enforced. So we're looking at the position in general terms when there is no longer a code right capable of being operated, but the apparatus remains on the land. And it means that you can't remove it, that is, the landowner can't insist on its removal, until you go through the Part 6 procedures. Paragraph 37 has assumed some significance in the argument against us, but all 37 is doing, as the title says, is identifying when does a landowner have the right to require removal of electronic communications apparatus. And one says it's got to be a person with an interest in the land, and it's got to comply with one or more of the following conditions. The first condition is that the landowner has never, since the coming into force of this code, been bound by a code right, entitling an operator to keep the apparatus on, over or under land. And the second condition is that a code right entitling an operator to keep our apparatus on or over the land has come to an end or has ceased to bind the landowner as the result of paragraph 32(1) or as the result of an order under paragraph 32(4) or 34(4) or 6, or where the right was granted by a lease to which part 5 of this code does not apply. Just pausing there. That means that there was, the second condition, there might have been a right once, but it's come to an end, and it's come to an end in accordance with the termination procedures. That's what is being driven at here. So it's not that it's just come to an end for no reason. It means you've got to the end of the procedures. And that's an important point when one considers a point that's made against us as to the terms of paragraph 40, subparagraph 8, which is really where we're going with all of this. Then the next subparagraph 4 has been used by Mr. McGee to make a point about occupation, but let's just remember what it says, and I'll come back to his submission. The landowner does not meet the first or second condition if the land is occupied by a person who conferred a code right, which is in force, entitling an operator to keep the apparatus on, under, or over the land, or is otherwise bound by such a right, and that right was not conferred in breach of a covenant enforceable by the landowner. So there's an extra hurdle that the landowner has to overcome, which is that if it's still occupied, if the land is still occupied by a person to whom a code right has been conferred, this is little Roman 1 in parenthesis, which is in force.
Well, Roman numeral 1 is not talking about a person to whom a code right is conferred. It's talking about a person who conferred the code right. Mm.
Yes. All it means, though, is that the... Yes, I see. So all it means is that the landowner's right to move in, to insist upon the removal of the electronic communications apparatus is deferred for such time as there is somebody in occupation who granted the right.
Yes. Yes, so if someone has properly granted the right, someone higher up the hierarchy of interests in land can't exercise his right to get the ECA removed.
So just thinking of the position that might exist, suppose you have a superior landlord and then a landlord who grants the code rights, and then a tenant who is the operator. And the operator's tenancy has fallen in, it's come to an end, and the tenant, his landlord is still in occupation of the premises, and the code right is still in force. Then the superior landlord is not entitled to seek the removal of the apparatus unless it's a breach of covenant. This is B. That code right is not conferred in breach of a covenant enforceable by the landowner.
Yes, if the occupier has within his contractual rights vis-à-vis the superior landlord granted a code right to an operator, then the landowner can't, and that code right is still in force. The landowner can't get the ECA removed.
That's right.
Yes.
So there we're looking at the occupation of the intermediate person, as it were.
Yes.
And for so long as that person is there, then, and therefore the code right is capable of being exercised because it's still in force, then the superior landlord has to wait until that situation is resolved before he can take steps to insist upon the removal of the apparatus. So this is, in other words, this is simply about injunctions, in effect. If a landowner has the right to insist on the apparatus being removed by injunction or whatever, because that is the right, his property right, then he cannot insist upon that if somebody deriving title from him is still in occupation and is the person who has conferred the code right. Now that doesn't tell you anything about actual questions of occupation. It simply tells you, it simply presents a restriction on the superior landowner's right to enforce the removal of the electronic communications apparatus.
I think it's said against you that if it's the case that the person who conferred the code right is no longer in occupation because it's the operator who's got the apparatus on the land who's now in occupation, then what's said against you is that this is then limited to only those cases where the installation of the ECA is just attaching an antennae to a roof. It doesn't result in occupation, but in the majority, perhaps, of cases where, on your argument, the operator does become the occupier, then this provision doesn't protect them from the actions of the superior landlord. I think that's the point.
I mean, yes, that is the consequence, but that is all about the occupation and the purposes of this particular clause for the meaning of occupation in that context. It doesn't give you any indication more widely than that about how this code treats the issue of occupation by an operator for the purpose of conferral of rights. That's the most that can be gained from it.
Sorry, I didn't quite understand your answer. Are you saying, yes, you agree that it only does provide protection in those smaller, in that subcategory of situations where even on your case, the operator doesn't become the occupier? Or are you saying, no, one doesn't have to apply the word occupied in the same way for this provision as you do for conferral of rights? Everybody who confers the right is may still be occupying the land for this purpose, regardless of the extent of the apparatus installed.
I'm not giving a definitive answer. I'm saying that this is a point which arises in this context. And one answer may be, well, you just look at the position of occupation, and the position on occupation is that that relevant person is not in occupation of the land that's covered by the apparatus, and therefore the landlord is free to exercise his rights. That's one possibility. Another possibility is that occupation must cover something wider than that. The occupation must include, for these purposes, the land covered by the apparatus, and you therefore have resort to the sort of cases that my friend has resorted to, the Graysim Holdings and so on, to say, as a matter of statute, in this particular context, one must look at occupation to mean that it includes the land that the occupier would have occupied if the electronic apparatus hadn't been there.
Yes, because otherwise it would be a rather irrational provision which is designed to protect the operator who has received a code right from an occupier, however defined, from an order to remove the apparatus at the hand of a superior landlord.
Yes.
If it were to turn on whether or not the grantor or the grantee of the rights was in occupation, there's no obvious policy reason for such a distinction. So
Yes.
you're saying, well, at least in this context, you may have to take a wider meaning of occupation.
Exactly, a pragmatic view to apply
Yes.
to the circumstances.
Yes.
But that
It's a rather
doesn't say-
dangerous course for you to go down, isn't it? I mean, once we start saying that you can ignore the occupation of the operator, then you know, why not apply that to paragraph 9?
My Lord, because those are two different situations. What you can't do, and this is the flaw in my friend's reasoning, is he takes a little snapshot of one situation where a particularly narrow application, a particularly narrow provision applies, and then says, well, there we are, you've recognised it in that situation, therefore it must apply across the board. That's not the point. If you recognise a flaw in a particular situation, then you have to deal with that flaw in that situation. And it doesn't tell you anything about what was intended in relation to another part of the code and another situation. So, I mean, I'm not... I mean, I'll come to this. The similar kind of thinking applies in relation to paragraph 26 when we get there. You remember that that's the interim rights.
Just before we move away from this, I'm not sure in which direction this point cuts, but it seems to me that subparagraph 4 isn't just to protect the rights of the operator, it's to protect the rights of the person who conferred the right, because presumably they're being paid for the code rights under the agreement. And if the superior landlord could come in and remove the equipment, they would stop being paid for that.
Yes.
So this enables them to go on receiving what they thought they were going to get under the agreement.
Yes. I mean, one of the points I was going to make was that the restriction that this is aimed at is about clearing away that intervening occupier to make sure that the superior landlord, in my example, has the right to get at the electronic apparatus anyway. So I entirely accept my Lord's point that it follows from that you might think this is in the protection of the occupiers, sorry, that is the intervening person's rights.
Well, it protects both
them and the operator.
both sides of the code agreement.
And allows that to continue. Yeah. So that's 37.4. And then, if I could just look at 38, just to correct what might be a difficulty that emerged from Mr. Sietler's submissions. 38 is nothing to do with anything, because this is about a landowner or occupier of neighbouring land who has the right to require the removal of electronic communications apparatus. And I picked up a reference that my friend Mr. Sietler made to what is said in paragraph 41, sub 1, the right of a landowner or occupier. Just to be clear, the occupier in that paragraph is the occupier of neighbouring land, because that's the occupier referred to in 38. The landowner in 41 can be either the landowner under 37, or the landowner of neighbouring land under 38. But 38 and occupiers of neighbouring land is altogether irrelevant for the matters under consideration by the court. So let's go to paragraph 40, which is all about, under the heading, how does a landowner or occupier enforce removal of apparatus? And the right of the landowner or occupier to require the removal of electronic communications apparatus on, under or over land under 37 or 8 is exercisable only in accordance with this paragraph. And then there's a notice procedure, and some provisions are made about that. And then at 6, the landowner or occupier, again, we can forget about the occupier, may make an application to the court for an order under paragraph 44, which is removing the apparatus, or an order under 44.3, which is selling apparatus. And then I don't think there's anything turns on 7. And then 8 is the subparagraph to which significance is attached, which is on an application under subparagraph 6 or 7, the court may not make an order in relation to apparatus if an application under paragraph 23 has been made in relation to the apparatus and has not been determined. So clearly here, for the purpose of removal of apparatus, it's contemplated that there may be an outstanding application under paragraph 20 which needs to be resolved before the court will go on to consider questions of removal. And it said that, I'm quoting from my friend's, Mr. McGee's skeleton at paragraph 50, that an operator with ECA on land may make an application for code rights to be conferred on it under paragraph 20. Now, that doesn't follow from what we've seen in 48. It's not saying that the outstanding application under paragraph 20 is an application for conferral of code rights. So we have to think about what is likely to be the application under paragraph 20 that is being referred to under paragraph 48. And what we've seen is that the general position must be something like this. An operator has some ECA on land, presumably in practice present because he's had some agreement, has the benefit of some agreement voluntarily or imposed by the court to enable him to put his apparatus on. The situation is then that his presence on the land, his apparatus on the land, has never been agreed by the landowner. So the landowner has never been bound by a code right. And so that means there's never been an application under paragraph 20 against that landlord. And therefore there's never been any question of a Part 5 renewal against that landlord. So in that instance, that is a landlord who has never been bound by any code right that undoubtedly was once given. Another situation contemplated is that it was granted in breach of covenant to the landlord. Again, the issue is, well, in breach of covenant, that breach of covenant has not been overborne by any Part 20 application as yet, and therefore the landowner is not restricted in his requirement to remove the apparatus. And the final thing that's contemplated by the sections is that a code agreement was once binding, but has since ceased to be binding. And thinking about those, that means that there was once an agreement which had been effective. We've seen under Part 5, you can only clear away an agreement that has been once granted by using the procedure under Part 5. So that possibility assumes that you've gone all the way through the Part 5 procedure and the right, the code right has come to an end, and the right binding on the landowner has also come to an end. Must be under that procedure. And so in any of those situations, the landowner wants removal. Now, the first line of defence, one might say, available to an operator who wants to keep his apparatus on site is to say, well, I've never yet made an application under paragraph 20 to bind the landowner in any particular respect to the code rights that I had. And I never lost that right. I could have any time made the right to bind the landlord to the code rights. My Lord Legate made the point to me this morning that there's no restriction on an application of that kind to bind a third party. And I accepted that. And one sees the effect of that point in this context, which means that the first line of defence that's available to the operator would be, well, he's not bound. Perhaps I can get a bit more time by making him bound by the code agreement. And therefore, I'm going to make an application under paragraph 20 to try and get some rights binding on him and therefore prevent him from pursuing his rights that he otherwise have to insist upon the removal of the apparatus. Now that is precisely the kind of paragraph 20 application that is being contemplated by paragraph 48. What you're not contemplating is that the operator will start again with trying to obtain new code rights under paragraph 20 in a situation where there has already been, one assumes, some litigation which has resulted in the landlord not being bound by some rights. Or at least where those rights are still available to the landlord. So it's not about the operator starting again from scratch and getting a new set of rights. For the reasons I've already set out this morning, the position during the currency of the agreement is that you cannot get anything further and you cannot bring it to an end without going through the Part 5 procedure. It follows from that you can't make an application for the conferral of further rights under paragraph 20. So that cannot be what paragraph 48 is considering. But the natural logic of a situation like this is that it's the application to bind the landlord which is going to be the application made under paragraph 20. And all that 48 is considering is that where those two things exist, then you deal with the paragraph 20 application first, and we see the outcome of that, before you then consider whether or not there should be any removal at the behest of the landlord. So,
as I understand, it comes to this on your submission. Paragraph 9 is excluded because Part 5 is the exclusive regime for varying the agreements. This provision is contemplating an application under paragraph 10.4, which hasn't yet been made but could be made against the superior landlord.
Yes, yes, leading to an application under paragraph 20.
Yeah.
Yeah, exactly. And now, once one has worked through the logic of the scheme, and you realise that there is a type of paragraph 20 application that can be made against such a landlord seeking removal of apparatus, then my friend's thesis, which is that the paragraph 20 application in question must be about conferral of rights on an operator simply falls away, because you can't draw that conclusion. Paragraph 48 doesn't say in express terms that, as my friend puts it, it's an application for code rights to be conferred on it under paragraph 20. It just says it's whatever application, any application, if an application under paragraph 23 has been made.
And you say there are, even on your case, some applications that can be made under paragraph 23 by an operator occupier, namely those to bind the landlord rather than the which don't get into the paragraph 9 problem.
Exactly. And so that's not an indication of anything that supports my friend's argument. A separate point which the Court of Appeal accepted is this. 48 does not talk about an application under paragraph 20 in relation to land or the site or the place where the apparatus is. It just talks about an application under paragraph 20 has been made in relation to the apparatus and has not been determined. So the point there could mean this. The paragraph 20 application that has not been determined is not an application that involves these current parties on this particular site. It's an application about a new site to which the apparatus is going to be transferred when it's removed. And Lord Justice Lewison, his judgment, accepted that point. This is dealt with in the Ashlock decision at 76, 78 and 79, paragraphs that is. So we also point to that as a possibility, and we say again, the existence of that possibility means that Mr. McGee's thesis that it has to be referring to an application for brand new rights to be conferred is just wrong. It can't be. So I'm now going to move on to the two sections, the paragraph 26 and 27, and see how matters stand there. 26 is the interim rights provision. Which is on page 1824, under the heading Interim Code Rights. An operator may apply to the court for an order which imposes on the operator and a person on an interim basis an agreement between them which confers a code right on the operator or provides for a code right to bind. Two, an order under this paragraph imposes an agreement on the operator and the person on an interim basis if it provides for them to be bound by the agreement for the period specified in the order or until the occurrence of an event specified in the order. And then there's a notice procedure which has to be gone through, and dropping down to 7, subparagraph 8 applies if an order has been made under this paragraph imposing an agreement relating to a code right on an operator and a person in respect of any land, and the period has expired, and so on. And then at 8, from the time when the period expires or the event occurs, that person has the right, subject to and in accordance with Part 6 of this code, to require the operator to remove any electronic communications apparatus placed on the land under the agreement imposed by this paragraph. So you've got limited or interim rights for a limited defined period, after which the right will arise for the any apparatus to be removed. And there's nothing about the purpose for which this paragraph is enacted. And so it's of perfectly general import, and we've had a few cases about it. Now, the gloss, as it were, that's been put on it by the cases, and I'm happy to accept for the purpose of my argument, is that, first of all, it doesn't need to be an application in the context of a paragraph 20 application. It can be a freestanding application for short-term rights, effectively. Hence my Lady Rose's observation that it's actually better called the temporary rights regime. But anyway, it's called the interim rights. So where it's for temporary rights only, then it doesn't need to be coupled with paragraph 20. A short term is allowed. It comes to an end. The apparatus is then subject to removal under Part 6, as provided by subparagraph 8. So there's no problem of any description in any of that. Where it's made, an application is made in the context of an application under paragraph 20, the application may be for conferral of rights, or it may be for binding a person, but at all events, the application is made in the context of that. It may be that no change of occupation is envisaged at all by the exercise of the rights that are sought. So in those situations as well, there is no problem raised by any of the paragraph 26 rights. The sort of things one might think of are access rights or multi-skilled visits, as they're called, MSVs, which is inspection rights, that kind of thing. There are lots of rights which do not involve any change of occupation. So there's nothing that's causing a problem, a practical problem, in the operation of this paragraph. What we're only concerned with here is where the interim right does involve some hypothetical change in physical occupation when it's exercised. So it's not necessarily going to happen, but it may be. It's a possible outcome that there's a change in physical occupation by having some apparatus moved on site short term. And the operator is making an application under paragraph 20 for the conferral of rights which have not yet been conferred.
Can you have situations in which both 26 and 27 are available? I mean, or
I would say not. When we come to 27, we can see that it's very late on in the process. It's right. You've lost all your other rights, and you just need something to allow you to keep your apparatus in good order, pending the final stage, as it were, of removal. So
I see.
This is rather more at the beginning. The temporary right seems to be more at the end. As a general.
So it can be used, this as a sort of as an interim application, if you like, yes, when you're making a longer term one under paragraph 20.
Yes. So the difficulty that's been identified by my friend is that limited class of situation where you are seeking conferral of rights, but under your own interim application for interim rights, you yourself have changed the occupational status of yourself and thereby perhaps ruin your own application for the conferral of rights. Now, I am quite prepared to accept that in those circumstances it would be quite absurd to say that you look at the physical occupation of the operator under his interim rights as in some way interrupting the occupation of the occupier against whom the rights are sought to be conferred.
Sorry, could you just repeat that?
Perhaps I could...
No, just say it again, I didn't...
Well, I'm not sure I will be able to say it.
Your basic point, I think, is that it would be absurd to look at the physical interim occupation as excluding paragraph 20 application. I think that's the gist of what you were
Yes.
getting at.
It's in paragraph 20 application, you're assuming that an occupier is the occupier, and you've given notice, as we've seen under the, you've given notice to somebody on the basis that he's the occupier, and you want an agreement from him conferring rights. You then make an application against him because he's the occupier, and you will shortly be arriving at a trial in which your contention will be that he is an occupier who can grant you rights. Now, the suggestion is made that because the operator has made an interim application and has gone into some kind of occupation under that interim application, he somehow must have shot himself in the foot because he's, the physical occupation has changed, and he can no longer claim that the occupier is the occupier. Now, that's the absurdity.
Well,
And we
the
quite
suggestion
agree.
is being made by you, according to Mr. McGee.
Well, no, I've never said anything about paragraph 26. It's nothing to do with my case. What he's positing is that in an application like that, where his type of client, his operator is making such an application, he would have shot himself in the foot. And it would be said against him by a landowner in such a context, I allowed you to go into occupation. I didn't oppose your interim rights because I knew you changed my occupational status, and therefore you've argued yourself out of court.
Well, he says that shows that it would be absurd if the operator could be the occupier under the code.
I agree. I'm accepting that would be absurd.
In that context.
In that context.
But you seek to isolate that context from
Yes.
Is that your approach?
That's
You pick off these piecemeal, but they don't add up to any big picture.
Quite. Because there is a very obvious absurdity in that sequence of events and in that contention, which is not any absurdity in the context of paragraph 9.
So you're not trying to make anything, as I understand it, you're basically conceding that in this context, the case against you is a good one. But in the limited circumstances in which you're talking about.
Yeah.
But you're not drawing any help, are you, from the deeming provision of 26(4)(b)?
I'm not on this one.
What is your answer to this one?
Can I just go back a stage to my Lord Borough's observation that I'm conceding? I'm not. I'm conceding that something needs to be done about the absurdity.
Yes.
I'm not conceding that...
I think we understand that.
Yeah.
All you're saying is that in this context, interim occupation is to be ignored.
Yes. But when it gets to trial, and the point I just wanted to make to round that off is when it gets to trial on that paragraph 20 application, in the context where there's been some interim occupation by the operator, how would the court treat it? The court would say, I'm interested in whether you, the occupier, are still the occupier. You certainly were at the time of the notice. You certainly were at the time of the application. And you will be again when this short-term right has come to an end. And the question for the tribunal will then be, does the fact that a short-term right of occupation was given to the operator under this paragraph mean that you've lost your status as occupier for the purpose of paragraph 9? Now, that is a very narrow question. It's not, because an operator was in occupation, we must, in every situation, think of some means of getting rid of any conflict between occupiers and operators.
But how do you get rid of it in this particular case, as a matter of construction?
And it may be there are a number of possibilities.
Sorry, you were about to explain.
I was going to say, it may be a number of possibilities, and as I say, I'm not here to argue the case. because it's an absurdity. So, but because it's an absurdity, you might think of it in a number of different ways. One is to say that in this situation, where the rights are granted to somebody in the teeth of opposition by the landlord, it doesn't affect his continuing, as it were, substantive occupation otherwise. Another would be to say, if the landlord had effectively consented to the interim rights being performed, that the presence of the operator on site was simply a reflection of the landlord's own right to occupy. So just to take that one further through, occupation doesn't mean by you alone. It means by you with your servants, agents, licensees, invitees. It's your right of occupation means that you can allow various other people to do things on your land, and that's a reflection of your occupation. So one solution there might also be to say, well, the interim rights need to be sought against an occupier. That's what it says, the occupier. That's why they're sought from you. And therefore, the rights for so long as they exist are a reflection of your occupation, continuing occupation, and not because some new occupation has been taken up by the operator.
Well, that's really analogous to actual possession and constructive possession, where you can possess through someone else. But can you occupy through someone else?
Well, the most obvious case is where you have residential property and you occupy some of it and your children are upstairs. And if the situation is that they physically have the ability to use a bedroom and indeed to shut the door, it doesn't mean that they have any kind of occupational right or status in relation to that part of their room. It's that kind of issue, and you can multiply that up across the board. So you can invite people to stay. You can leave your house and have a house sitter, and therefore they are in sole control of the house for as long as you're away, and still you're the occupier. Occupation does not require actual occupation 24/7 by you alone. It's a status that you look at, looking at all the evidence, which includes the rights that you've allowed to exist in relation to your house. So yes, my answer to it, that one way that the court, looking at the paragraph 20 application, would consider resolving it is to say, well, you never lost your occupation merely because you've allowed, or the court has imposed, these temporary rights on you precisely because you're the occupier. It doesn't make any sense. But you don't need to do any of those, amendment to the meaning of occupier, or the meaning of the concept of occupier in such a situation. It's an observation that doesn't go anywhere. There's an obvious solution, and it has no effect on the proper approach to paragraph 9. So that's what we say about paragraph 26. And then we go on to paragraph 27, and our general submission there is that the position for my friend is no better. The key to paragraph 27, or the key to its application, is at 27(1)(c), which is at page 1826. Under temporary code rights, this paragraph applies where, and C is the crucial thing for my purposes, the person has the right to require the removal of the apparatus in accordance with paragraph 37 or as mentioned in 41, but the operator is not for the time being required to move to remove the apparatus. So let's with that as a sort of indication of timings, as it were, that means we know that this is quite a long way down the line. But 27, well, you can go back to A. You have an operator who gives notice under paragraph 22 to a person in respect of any land. The notice requires that person's agreement on a temporary basis in respect of a right which is to be exercisable in relation to ECA, which is already installed on the land, and the person has the right to remove it. Now, in those circumstances, the objective of the right is at 3. The objective is that until the proceedings under paragraph 20 and any proceedings under paragraph 40 are determined, the service provided by the operator's network is maintained and the apparatus is properly adjusted and kept in repair. Now, as we've seen, when we get to questions of removal, so we're looking at the C, the outstanding position of a person with a right to require the removal of apparatus in accordance with 37, or as mentioned in paragraph 41. I've already been through why under the Part 6 procedure you may find that there is a paragraph 20 notice. And the essence of my argument in relation to that was that it's easy to contemplate in that context that the first line of defence for the operator would be to try to make the landlord bound by a right that he has not yet been bound by. It may be late in the day because the landlord has the right to remove, but one answer to his right to remove may be to make a paragraph 20 application against him. And that therefore gives meaning and effect to the existence of the paragraph 20 application, or notice I should say, which is contemplated by 27(1)(a). And the purpose of the notice is to require rights to be given on a temporary basis, and the person has the right to require the removal. So we are looking at that kind of situation, and a notice procedure is therefore put in place for temporary rights. So
but paragraph 27(2) seems to encompass both an application to confer rights on the operator and for a person being bound by it. It doesn't look as if it's limited to the kind of application under paragraph 20 for binding someone under 10(4).
Yes, well, I should go through. The paragraph 2 says that the court may, on the application of the operator, impose on the operator and the person an agreement which confers or provides to be bound by such temporary rights. So this is about how you get temporary rights conferred in the situation that I've described. And they are such as appear to the court to be reasonably necessary for securing the objective. Just to round that off, the objective under 3 is a limited one, which is until the proceedings under 20 and any proceedings under 40 are determined, the service provided by the operator's network is maintained and the apparatus is properly adjusted and kept in repair. So it's a limited right that you haven't got rights, or you haven't got rights against a particular person. And you need to get some temporary rights of this basic nature just to keep the apparatus in repair pending determination of the issues that are raised under the other proceedings. And that's all it is. And as I've indicated, it's perfectly possible for to contemplate circumstances in which that can be done without entering into the sort of issues that my friend is raising here, saying that they fall foul of the principle in paragraph 9 that rights need to be conferred by an occupier. Now,
can I just see if I've got it right? So what you're saying about subparagraph 2 is it's not dependent on the mechanism of paragraph 9 at all, because this would be the court conferring a new right. You need to have a right. Yeah. This is contemplating that there may need to be brought into existence a code right which didn't exist before. But it's the court which can make the agreement which confers that right on the operator, so no question of occupation. Paragraph 9 is not the mechanism. And then the second limb of it is that you might also want other people to be bound by that code right as created by the court.
Right.
Okay.
So that the court, in this particular case, can order the conferral of a code right sort of outside paragraph 9.
That's right. And the way you get to that last stage, outside paragraph 9, is that when the court orders the temporary rights, subparagraph 4 applies, which includes paragraph 22, and paragraph 22 says that the agreement takes effect as an agreement under Part 2. So in paragraph 27, and my Lord Burrows raised this with me earlier, but in paragraph 27, yes, we do rely on 4b. It's not quite apposite in 26, but 27 is bang on what you need. And it's just the same as 34.8 in the context of a renewal, because this is about the court ordering some temporary rights or some new rights that don't otherwise exist. And there's a deeming provision that makes it rights that are that take effect as rights under Part 2. So there is, in short, no difficulty whatsoever under 27, despite the fact that, as my friend puts it, that is one of the two key reasons he gives for why he should seek to reinterpret, effectively, paragraph 9. And we support the conclusion of the Court of Appeal in Compton Beauchamp that in any case, nothing undermines the essential principle that code rights can only be conferred by agreement with an occupier. That's at paragraph 69. So if there's nothing in 26 or 7 that requires any amendment to be given to paragraph 9, or the operation of paragraph 9, that essential principle. Ditto, we've looked at 37.4 and 41, and we can't find anything there that points to a general inroad into the principle established by paragraph 9. And so,
what is the principle then, if there are all these exceptions to it? I'm beginning to wonder what the point of relying on paragraph 9 is at all. You rely on it to stop the operator from applying under paragraph 20 for new rights, either during the currency of the fixed term agreement, part of the agreement, or when they're in the transitional provisions. But why do you have to hook your prohibition on paragraph 9? Why don't you just argue the regime doesn't contemplate them being able to do that?
Well, I do argue that, and I'm sorry if that point hasn't come across, but I do say the regime is perfectly clear, and you don't get a chance to make paragraph 20 applications after the initial application has been made anyway. But separately, even if you were, or even if some new application could be made in particular circumstances, it would be met by the paragraph 9 requirement that you can only seek rights of conferral, that's new rights of code rights, by conferral from the operator and the occupier. And what I would emphasise about these provisions that we've gone through is not that there are, as my friend would have it, that there are indications that the legislature was aware of the possibility of non-occupiers or operators being occupiers as well, but rather that at various different stages, the legislature insisted on a deeming provision to make sure that whatever the difficulties, a particular class of right would be or would take effect as a right under paragraph 9, right under part 2, notwithstanding that it might have fallen foul of the paragraph 9 requirement. So we have these deeming provisions that appear in different contexts, essentially on renewal and on paragraph 27 on the grant of temporary rights, which points in entirely the opposite direction from what my friend is asking to say. They point in the direction that when the court, when Parliament stated that only an occupier could confer code rights, it meant it. If I could round off my reply to my friend's submissions as to the meaning of the code, I think I just need to take the court to the few extra ones that have cropped up in argument. These are possibly the submissions are rather disjointed, but the first point that's made is under 100, subparagraph 2, and that's at page 1871. And my friends, I think I understood my friend correctly to say that he was not saying that there's anything in this last category of paragraph which points to the existence of an occupier-operator as a relevant concept for the purpose of any part of the code. He was just saying, in effect, that there are some suggestive terms at the end of the code in the supplementary provisions which may have some bearing on the argument. So he's not putting his argument, as I understand it, on the meaning of any one of them. But let me just take the ones he says. 100 is the first, and this is the one headed Relationship between this code and agreements with operators. And it says, this code does not affect any rights or liabilities arising under an agreement to which an operator is a party. And then subparagraph 1 does not apply in relation
which
to...
page?
Sorry, 1871. Does not apply in relation to paragraph 99, which we can ignore for present purposes, or parts 3 to 6 of this code. Now, I agree with my friend, it's a rather convoluted way of doing it, but what it means is that whatever contract you have is sacrosanct, except you can't oust parts 3 to 6 of the code. So that's the provision, for example, that enables us to say with confidence that the minimum rights of upgrading and sharing in paragraph 7 cannot be avoided by some kind of consensual agreement. Clearly, Part 4 is part of things. You can't oust the jurisdiction of the tribunal under Part 4 or anybody's ability to make an application. That is the operator's ability to make an application for conferral of rights or to make rights binding on the landlord. So you can't confer that, sorry, you can't oust that by agreement. 5 and 6, you can't, we've looked at those. 5 is the termination and modification and renewal provisions. You can't oust those, and you can't oust Part 6, which is the how you get apparatus removed when somebody has the right to insist on its removal.
Does this also apply to knock out what was described as the estoppel argument, if it were needed?
Yes, I hadn't thought about that. It's only parts 3 to 6 which are affected. Part 2 isn't affected. So
no, so it doesn't apply. It doesn't apply to
the
doesn't apply to Part 2.
Just the estoppel argument relates to Part 2.
Yeah.
Yeah, that's probably right, isn't it? So yes, so we have parts 3 to 6, but it doesn't tell you that there's any particular issue about any of those parts that is being identified in any of this. It just tells you, as a perfectly general position, that you cannot contract out of parts 3 to 6. That's it. There's nothing else, and there's certainly nothing for the purpose of this argument, this issue before the court, that can be derived from 102. The second thing my friend looks at is the provision of 101, which is the section effectively about fixtures.
Yeah.
The ownership of property does not change merely because the property is installed on or under or affixed to any land by any person in exercise of a right conferred by or in accordance with this code. And I think my friend also in this context referred to the definition at 108 on page 1875 of the word land as meaning land does not include electronic communications apparatus. So all that this means is that land is separate from apparatus, and it doesn't matter for the purposes of the workings of the code that apparatus may have been sunk into or otherwise affixed to the land. That's not a relevant context and concept, and it doesn't have any effect on the operation of the code. But the consequence of that is simply that it doesn't make any effect on the argument as to who is the occupier. So the actual fact of occupation is demonstrated as much by affixing electronic communications apparatus to the land as it is by sitting it on the land.
Yes. So the ECA may remain the operator's property as a matter of the law of property, but the placing it on the land, you say, is a form of occupation.
Yes.
And these provisions say nothing to the contrary.
That's right. Yes. So I don't think I need to make the point any more forcefully in that. So I look, therefore, back at the code as a whole, and my general submission is that the code works as intended, and one doesn't need to make inroads into particular words, such as the word occupier in paragraph 9, where there's no reason to think that The code otherwise was intended to apply something different.
So what is, we seem to have narrowed down then the consequences of saying that the operator becomes the occupier when he installs his ECA. It doesn't affect his ability if he's installing it pursuant to a temporary right or an interim right. The effect of it is then that is limited to preventing him from making an application under paragraph 20 for conferral of rights when he's already present on the land pursuant to an existing agreement.
Quite.
So I'm still struggling to see, well, why is it helpful to determine whether that's a proper outcome by focusing on the word occupier or not?
Well, simply because, as my friend puts it, and indeed I agree, paragraph 9 is the fundamental principle. And that says you can only have rights conferred by an occupier. So, and this is my friend's point, he says, I've got no rights now, so I want to get some. I can only, under paragraph 9, go to an occupier, but that doesn't work for me here because I'm the occupier. So it must have meant something different. And my answer to it is, that doesn't follow at all. You go in loving detail, as we have done several times now, through the code, and the code simply doesn't contemplate anything other than what it says in paragraph 9, which is you can only have rights conferred by an operator. I'm going to come separately, if I may, to the consequences of doing something about paragraph 9, which is what you're being invited to do. And I'll do that later on in my submissions, if I may. But for the moment, I'm just looking at the code, and there's no indication, my submission is, there's no indication in the code that at any stage, paragraph 9 was intended to have some kind of different meaning. On the contrary, the point I think I've already made is that the deeming provisions suggest strongly that that actually is the basic principle that should be observed throughout these grants of rights. Now, in the time available to me, I've got quite a lot to cover, but I better move off the code and onto the transitional provisions. And I might be able to do this without looking them up because the court's seen them.
You have, of course, till 3 o'clock because of the 40 minutes that was taken by the appellants.
I'm afraid I've already taken that into account, and I still think I need to move on.
But I just wanted to confirm that you understand
that position. Yes, I do. Thank you very much for reminding me, my Lord. So I'm going to move on to the transitional provisions. The basic scheme that the court will have seen is that existing agreements are entitled to be treated as new code agreements as provided. And the particular provision is the concept of so-called subsisting agreements. So subsisting agreements are protected by the new code. Agreements which are not subsisting agreements are not protected. There's also some protection for current old code applications, and they are to be treated as applications under paragraph 20, but that's not relevant to anything before the court. And there's one exception to subsisting agreements, which is also provided for, which is that subsisting agreements which have protection under the 54 Act will not renew according to Part 5, but will renew under the 54 Act. And then I think my friend and I are agreed that as a result of the operation of the Landlord and Tenant Act, or amendments to the Landlord and Tenant Act, that effectively means that you get a renewal once only, and then your next renewal will be under Part 5. Now that is a specific transitional provision, and it does have effect in the matters before your lordships and your ladyship, because one of these cases is a 54 Act case. And I want to go to that straight away, and that's the Ashlock case. And the first point I want to make about it is that there were two quite separate issues that were argued in the Court of Appeal. One was that the court was bound by Compton Beauchamp, and so Cornerstone could not apply against Compton Beauchamp, the landlord, because Compton Beauchamp was a non-occupier. And that was a novel point on the tripartite situation that existed then. The idea was to make an application, Cornerstone being a new person, was making an application to the, as it were, the overall landlord, despite the presence on site of Vodaphone's apparatus. And so this was a deliberate application to have rights conferred by a non-occupier. So that was the first point, and the court on that point said it was bound by Compton Beauchamp, and it rejected the point anyway. But there was a separate, independent point, which was as to the proper interpretation of the transitional provisions. And I'll take, it might be appropriate just to take the courts to some part of it. The point being that these were not cumulative or interdependent issues, but quite separate issues. The Court of Appeal's conclusions on the interpretation of the transitional provisions were at paragraph 93 onwards, no, sorry, 86 onwards, which in the bundles, thank you, 748. That's under the general heading transitional provisions. The court's already dealt with the Compton Beauchamp position, and Lord Justice Lewison says, thus far I've considered the operation of the code independently of the transition provisions. It's now necessary to turn of those to those. Now he sets out the relevant provisions, and then from paragraph 93 onwards, he points out that transitional provisions are subject to the principles of construction, which he there summarises. And then he goes through how the transitional provisions actually work. And he gives some examples and applies the transitional provisions to them. And the conclusion that he comes to, the further parts of the reasoning are then given at 101, which is there are a number of further difficulties which would arise, that is under the transitional provisions, if an operator in the position of Cornerstone had an unfettered right either to seek the imposition of an agreement or apply to renew its lease. And then he goes through those that the Deputy President had identified, including the fact that if they were to have an alternative right to apply at any time under Part 4, that is paragraph 20, then that conflicts with the right to renew under the 1954 Act, which the transitional provisions was effectively saying was their only port of call for renewal rights. So 102, his Lordship says, I agree with that. It must be stressed that the particular problem which arises on this appeal only arises in transitional cases. If Cornerstone were to renew its lease under Part 2 of the 54 Act, The new lease would fall outside the scope of Part 2 as a result of 43(4) of that Act. It would also have been granted after the coming into force of the Code. It will not therefore be a subsisting agreement, and Part 5 of the Code will no longer be excluded because Part 2 of the 54 Act will no longer apply to it. The new lease will therefore be capable of renewal under Part 5 of the Code. So, fairly convoluted, but it's clear what the transitional provisions were intended to achieve, which is that 54 Act tenancies go to the 54 Act process. And there were policy reasons for that, which under the old Code, operators who had leases seemed to have dual protection. They could either go for further rights under the 54 Act, or they could apply under the old Code because there was nothing to stop them. So one of the purposes of the transitional provisions was to stop dual protection from being an issue. And then at 105, going back to the judgment, 105, the effect of the definition of subsisting agreement in the transitional provisions may have left some operators out in the cold, notably those who occupy under tenancies at will not recorded in writing, and possibly those holding under periodic tenancies protected by Part 2 of the 54 Act who cannot take the initiative to renew their tenancies under that Act. That, at least, is what Judge Cook decided in Arkiva. But that's not primarily a consequence of the Code itself. It's primarily a consequence of the transitional provisions, about the contents of which the Law Commission made no recommendations. And as we've seen, the government's position was that the revised Code should only apply to new agreements. And the only other point I'd draw...
This argument would succeed regardless of the meaning of the word occupy.
Yes, yes, that's the point.
Yes.
There are
then
two...
Cornerstone was not in occupation.
No.
So
this
why
is
was
Ashlock.
it a Oh, this is Ashlock.
This is the Ashlock one.
This is Ashlock appeal, yeah.
Cornerstone, Cornerstone, yes. Cornerstone was the tenant in that, the holding over tenant. So the point in Ashlock was, or the argument in Ashlock was, I, Cornerstone, know that I'm being told I've got to renew under the 54 Act, but I can also renew under Part 4, paragraph 20 of the new Code, because you tune out, as occupier, you tune out my presence there as the occupier, and you allow me as the operator to go straight against the landlord. So the first point to make about the Ashlock thing is that there's no appeal from the judgment on the interpretation of the transitional provisions. And that's a freestanding reason why the claim failed. Oh, sorry, I meant to mention the judgment of Lord Justice Davis as well, which this is agreeing with Lord Justice.
I have to disagree with paragraph 108.
Yes. He says at 110, I wasn't much moved by the appeals of Mr. Seitler to the asserted merits, and then makes the general point about halfway down that paragraph. The actuality is both parties are commercial concerns operating for profit. In truth, the underlying competing considerations reflect the fundamental dichotomy between the provision of communication services for the public benefit on the one hand, and the need for acknowledgement of private property owners' rights on the other, and the delicate balance that needs to be struck, that's probably, and maintained between the two. The transitional provisions are crucial in this case. As I read them, and I note they were not the subject of the Law Commission report, they directly confront this perceived dichotomy. As I read them, they give a degree of primacy, as it were, to subsisting rights. There was a clear concern about retrospective effect. That has an obvious policy purpose, and a reading of the provisions of the Code which is consistent with and can accommodate that purpose in such a context cannot therefore be said to be senseless. Moreover, if, as Cornerstone contended, Part 4 of the Code is to be available in the case of a subsisting agreement to which Part 2 of the 54 Act applies, then, as we submitted and as the Deputy President had observed, there is potential both for confusion and for conflict between the two different regimes. Very difficult to think that that could have been intended. So again, Lord Justice Davis was specifically focusing in that short additional wording on the transitional provisions. So my first point is there's no appeal against the finding on the transitional provisions. More widely...
So you say that's the end of the Ashlock appeal?
Yes,
yeah.
I do.
Can I just ask this? In answer to my lady, you said that the transitional provisions point gives you victory in Ashlock regardless of the meaning of occupier, and I think I followed your submission on that. Do you go further and say that the transitional provisions cast light on the meaning of occupier in Part 4 as well?
No, not as such. The main purpose as regards the Ashlock facts are to show the way in which the transitional provisions are definitive as regards those who can and can't come within their terms. So the transitional provisions provide for the new code to apply in certain situations and therefore for the new code not to apply in other situations. And where you've got these old rights to the left, you have to look at the transitional provisions to see where you stand and not to code rights generally.
And in this case, the only case that's directly affected by the transitional provisions is the Ashlock one. Is that right?
No, because, well, sort of indirect. I'm not sure what direct means in this, but there's the on-tower case is a case, and perhaps we could just consider that a moment. The on-tower case is a case where the operator did have electronic communications apparatus on site, but under a tenancy at will. And the argument was, is the particular form of tenancy that had arisen in the particular circumstances a subsisting agreement or not? The point being, if it was a subsisting agreement, then on-tower could access the code, in particular Part 5 of the code, for renewal rights. If it wasn't, then it couldn't access the code. But what's extraordinary about on-tower, and I'm not sure the position has quite come across. In on-tower, it was my side. I wasn't actually there before Judge Cook, but Mr. Clark was arguing that on-tower was a subsisting agreement. In other words, it was on-tower's position that, sorry, it was APW's submission that on-tower was entitled to access the code. So the submission being made by our side was there's no problem here because you're a subsisting agreement. So, use the code. But that wasn't good enough for on-tower, any more than it was in Ashlock. Ashlock...
when you say use the code, to do what?
To renew.
Under
Part 5.
Part 5.
So our submission was, you're a subsisting agreement. You can therefore access Part 5 of the code if you want some fresh rights, and there's a procedure for all that, and there's no problem. You're not out in the code, in the cold. But the on-tower submission was, we are not a subsisting agreement for various reasons, and therefore we are out in the cold, and therefore we need to make some kind of alteration to the Compton Beauchamp decision to allow us to make an application against an effective party who can grant us some code rights afresh. So that's how matters stood. Now, Judge Cook said it's not a subsisting agreement, and therefore we are into Compton Beauchamp territory, and we do need to understand from whom you can now get any rights at all. And that's why there was a leapfrog, and
Right,
we
because they fall between two stools.
Yeah.
So the problem really stems from the requirement in the transitional provisions that the agreement be an agreement in writing, when actually quite a lot of these sites have ECA on them, which is there under an unwritten tenancy at will.
Exactly so. But in expressing it that way, which is a way that I would adopt with respect, one can see that the problem is actually a problem under the transitional provision. It's not a problem under the code at all.
But as I understand it, we've got to look at all the provisions of the code, and we've got to look at the transitional arrangements across the board. I mean, you're here to argue the whole picture, and I'm just therefore troubled by the idea that somehow there's been no appeal in relation to the transitional provisions in relation to Ashlock, and that's the end of that side of it. I mean, surely we've got to look at this across the whole board and decide what we consider the appropriate approach, and then apply it, if necessary, to Ashlock.
Well, yes, the final result, however, may differ if there's no appeal on a particular point. So one can see that for the purpose of Compton Beauchamp and On Tower, that would be so. Narrowly, for the purpose of Ashlock, we would say there's no material appeal that enables them to succeed.
Well, why don't you just say, as you said with 26, 27, well, you can't really rely on occupier, meaning what we say it means for those purposes. Why don't you then similarly say, well, if it's true that it's not a subsisting agreement because it's not written, so you have to read code as meaning that occupation under something which is not a subsisting agreement within the meaning of the transitional provisions doesn't count as occupation for the purposes of paragraph 9, so that they don't then fall between the two stools, and you get round it in the same way as you're getting round it for 26 and 27.
I think our difficulty would be with the idea that they're falling between two stools. There's no stool available to them. There's a line drawn by the transitional provisions which says they cannot, effectively, they cannot access the code unless, of course, they are a brand new person coming to the site. Now that's all that this is about, is whether they need to restore the site to the occupier before making a new application. I mean, that just doesn't seem practical anyway. They'll go somewhere else. But that's theoretically the position they're in. So Ashlock is not out of the cold at all because it has 1954 Act rights. And the Court of Appeal said, in fact, you have to use your 1954 Act rights if you want some kind of further rights. On Tower, there is a solution available to them, but it's not because the code is a problem. They're not entitled to the protection of the code. It's because the transitional provisions excluded them from the code.
Yeah, what is the option open to them?
If they have to make an application against an occupier, they are in occupation, so they cure that by leaving. Then somebody else will be in occupation, and they can make an application against that occupier. That's where the transitional provisions leave them, essentially. I've rather run over.
We're slightly over time, but could I ask a question which arises out of this,
Yes.
this discussion? You said when I asked you, do the transitional provisions cast light on the meaning of occupier? And you said no. And I'm concerned not to be trying to magic up arguments that really don't work. But I wonder whether there is some implication from the form of the transitional provisions. So I'm looking at the transitional provision, paragraph 6, which is page 1878. And that only provides that Part 5 of the new code does not apply in relation to a subsisting agreement. So it doesn't disapply Part 4 if Part 4 is applicable in relation to a subsisting agreement. I follow the submissions you've been making that the intent of this part of the transitional provisions is to leave people with their 1954 Act renewal rights, and that's all. But I was just wondering whether, in order to secure that policy objective in relation to not just Part 5, but Part 4, whether it might be said that the Parliament, in enacting paragraph 6.2, has made the assumption that an operator under a 1954 Act lease is not going to have rights under Part 4, which need to be disapplied.
Is that something you'd like to come back?
Yes, but I just wanted to leave it with you. Yeah, have a think about it. As I say, I'm very concerned not to go down highways and byways in this complex area, which may lead nowhere.
Let me see if I can sharpen up a response.
Sure.
Over the shorter German.
The court will now adjourn. Thank you.